With so many people moving here to Tennessee from all over the country, today I wanted to do a video that sort of touched on what the legal aspects of real estate are here in Tennessee. The laws are different in every state, and I thought the best way to do that was to sit down with our in-house attorney, Griffin Dunham. Griffin is one of the owners of our sister title company, Momentum Title. He owns 3 different title companies. He's been an attorney for 22 years, and he's argued in front of the Supreme Court and won, right? Yes.
It's been a while, but yes.
It's been a while, but still, this is a guy to know. This is a guy we all go to here. And so welcome, Griffin. Thank you for doing this with me.
Appreciate you having me. Thank you.
Yeah. So next question is how to hold title in Tennessee. So I had some overall questions, but I also had a neighbor who had she sold a home in another state, in Michigan, I believe. And she bought a home with her. It wasn't a husband. It was a partner she'd been with for 30 years. They raised their children together. Anyways, they moved here to Tennessee, took the proceeds from that house that they sold in Michigan, bought a home here in Tennessee. When they went to sell the home here in Tennessee, they were breaking up. When they went to break up, she went through 7 attorneys before she found one that would take her because they were unmarried. And she had not worked. He had been working throughout the years. They were an older couple. They decided as a couple that she was going to stay home and be a daycare for their grandchildren so that their children didn't have to pay for daycare. So she was not contributing the same amount, even though the home they sold in Michigan, the part of the equity of that was, like $300,000 of an inheritance that she'd gotten when her mother passed. So she moves here, buys this house, they go to sell it, they're split up, and she finds out she's going to get practically nothing out of it because he was one paying for paying the mortgage the whole time. So,
was she on title?
She was on title. Yeah, she was on title. So she goes through attorney after attorney. They want nothing to do with her. There's no way to win this because you are unmarried, blah, blah, blah. So she finally finds a guy. I'll tell you his name off camera because I don't remember it right now anyways. But he said the only way she was able to is because she had a ton of receipts. She kept meticulous records and could go back and I don't want to get all the way into that because it was a long story, but she ended up winning. But she was told by all these attorneys that this is a very rare case like this. Because you're unmarried, you're not equally contributing to the housing. So anyways, as you're talking to clients that are unmarried and potentially going to partner up and own property together, I wanted to address this and kind of understand what happened. How do I don't want to say advise them because I'm not an attorney again, but how do I sort of guide them in this process of purchasing property together?
Well, they have to understand the risks. If you're not married, then you can be on title, but that doesn't mean that you're necessarily going to get, if you're just joint tenants who own property together, that doesn't mean that you're automatically guaranteed 50% of the net proceeds from the sale. In your situation, what it sounds like happened is that you had one person who was contributing to the upkeep of the property by paying the mortgage on it. And so that carries
bills and all that. Right.
Could be utility bills, could be annual gutter work, could be landscaping, could be any number of things. And so the default would be that you have 2 tenants that are equal owners. And then when there's a sale, then the net proceeds would be divided between the 2 parties equally because they have effectively a 50% ownership right by virtue of being tenants in common. There can be adjustments to that though. So if I'm the one who's contributed a lot more than the other person has, then and both people are unmarried, well then the person who's contributed more has what's effectively referred to as an equitable lien on the equity beyond 50% because of the contributions that they've made to the property and the value of the property by keeping it maintained, keeping it from being foreclosed upon, paying the interest that the other party didn't have to pay. So, of course, the principal pay down is a separate issue altogether. But I think that the advice to give to people who are going to take title and they're not married is keep receipts. Whatever you contribute to the property, keep a record of it. Okay. So I would establish a separate bank account, a separate credit card, and the only thing that it's used for is things for real estate. If you're going to put money into it and then it's going to come out because you're going to write checks to vendors, then do it through one account. Have one credit card so you keep that record. I also like to tell people never, ever, ever own property with someone unless you trust them. It's kind of not the person who's going to not take anything from your wallet. You go into business with or own real estate with someone who's not even going to open your wallet at all. Mm-hmm. Never going to look into it to see what's in there. And so that's the first thing, is you have to trust the person. The second thing is knowing that we live in a crazy world and things can happen. You never know what's going to happen. Maybe that person passes away and their heirs then succeed to their interest in the mm-hmm. property. Then you're going to have a fight with them possibly, and you want to have your records. So I'd say maintain it. I'd even go as far to say is that if depending upon the situation, instead of just being tenants in common, you can have tenants in common with the right of survivorship, mm-hmm. meaning that as soon as one party passes, that property is automatically and immediately vested in the other party from an ownership standpoint. So that would cover the situation of death. But otherwise, I think that the only thing you can have besides good record keeping and maintaining separation of accounts and not commingling funds is to have a contract. There's nothing that prohibits a contract. It's almost like a prenup for people who aren't married, who are going to decide on the front end the disposition of the property and the allocation of proceeds and the obligations each will have during the period of ownership, such that in the event that the contract's not satisfied, then you can start factoring in different credits that are going to be to the other party's benefit. Okay. It might have exclusions and prohibitions on partitioning the property, preventing the sale of the property in case one of them just decides to sell and the other one doesn't. Buyout provisions if one wants to sell and one doesn't. So I think between having a contract, one is not doing it to begin with. If you have to do it because you trust the person, then have a contract, separate accounts, separate credit card so that you can only use it for expenses related to it. And those are the things I would say to try to maximize the protection for unmarried people owning property together.
Okay, so next question. Can a prenup protect your real estate investment against state laws?
I believe so. Yes. Not a family lawyer.
That's true.
I should say that. Yeah. So I'll give you what I believe to be accurate, but with the heavy dose of, hey, let's make sure that before we make any life decisions, we figure out if this is real. And this is not legal advice to be relied upon. Nothing is. A prenup is a contract with your fiance or girlfriend, boyfriend, and it's going to decide what is part of the marital estate and what's not. Oftentimes is you go into a marriage and there might be an asymmetry of asset ownership and value, and there might be different bargaining power between the two parties, and it's just a contract where the parties agree on how assets will be divided in the event that there's a divorce. So the answer is yes, it can be a negotiated term and part of a prenuptial agreement.
Okay.
There's also a postnuptial agreement for those that would want to try to get some leverage after the fact. So much less common.
After a marriage, you mean? Then you get, okay.
Yes.
You're grinning. This could be an interesting story.
You just don't see it very much because after you get married, if somebody presents the other one with a postnuptial agreement, they're going to say no.
Yeah.
What are you going to do?
That's what I was just thinking. I was like, oh, okay, well, how does that work if you've already...
I think the only way you can do it is if you say, I'm going to divorce you unless you sign this.
Yeah.
and they'll sign it because the person's about to come into money from a trust account, or they somehow are going to be the beneficiary of a non-marital asset.
Yeah.
And so one of them says, look, we might not have been getting along too well in the past. If you want to be part of this, then you're going to have to sign this postnuptial.
Yeah. No, see, that makes total sense. Like if you're getting a big inheritance like this neighbor was, or something's coming, it's like, look, this relationship is not very strong. Let's, if you want to stay in it.
And I'm displaying my ignorance. I think I might have thrown out inheritance. What I should have said was property that would become property of the marital estate. And they're about to come into that.
Or that you didn't want to become part of the marital estate.
Right, or the may not have, but I'm quite certain that inheritance is not part of the doesn't become a marital asset.
I think I threw that word in there. I don't remember you saying.
I may have.
Anyways, I think I did it. But yeah, anyways, yeah. So that's okay. So we got all kinds of contracts can be signed for all kinds of reasons.
Contract for anything.
Yeah. Okay, so do unmarried parties need to contribute to the house expenses equally to be eligible to split the sale proceeds equally? So basically we kind of covered that already, but that's a yes.
I think so. Yeah. It doesn't have to be a perfect math formula, 50-50. It just is going to be that the allocation of the net proceeds is going to correlate directly to the contribution made between the two parties.
Okay.
So if I contributed 60%, then I'll get 60% of the net proceeds.
Okay. So does Tennessee recognize common law marriage?
They do.
Sorry, we're getting into family law, aren't we? I was kind of...
They do recognize them. It's so rare for that to exist. There are procedures in order to recognize it. And there are certain requirements. You have to live together for a certain number of years. It's just such a rarity that every time it comes up, I have to go look it up myself.
Okay. And what about community property state? Is Tennessee community property?
It's not. Think about West Coast. I think it's California is. I think Arizona is. I think New Mexico is. I don't know about Washington or Oregon. I think Nevada is. We're not. Community property state being that husband and wife own property 50-50. And usually that's how it's going to get split, is 50-50. Tennessee is much more protective. Tennessee has what's called tenancy by the entireties, where it gets a little complicated, but it's worth knowing. There's no more valuable way, protective way to own real estate in Tennessee than by owning it as husband and wife, or husband and husband, or wife and wife as spouses, where once that designation is made in a deed or in any other personal deed, it could be a coffee table. If you own something as a marital unit, then it's not exactly true, but the individuals don't own that asset 50-50. Instead, the marital unit kind of owns the entirety of the asset, and it's called tenancy by the entireties. A long doctrine, long time ago, and it was created to protect the marital relationship, and it was intended to protect those where, if say there's a judgment against one spouse, there are creditors against one spouse, they can't collect against a tenancy by the entirety owned asset, because then it deprives the other spouse of the enjoyment of the possessory interest that they have in that asset. So let's take real estate, and it's the exact same thing with coffee tables. So in Tennessee, if I am married to someone, I don't own 50% of the coffee table, and the spouse doesn't own 50% of the coffee table. So I would own, say, her, instead of that, keep in mind, the marital unit owns the coffee table. The only thing I actually own is her survivorship interest in that asset. And she only owns my survivorship in the interest in the asset, such that if she predeceases me, then I become the 100% vested owner of that real estate or of that coffee table.
Okay.
And so whenever you have a deed, husband and husband, wife and wife, if they are married, that deed should 100 times, I should take that back. The default should always be that they own that property as a married couple. Because then you get the protection of tenancy by the entireties. The only time that you would not is because there is an intentional strategic election by the married couple to deviate from the most protective way to own property. And it could be because they might see themselves getting divorced in 3 months or 6 months, and they don't want the property to automatically vest in the other one if they happen to pass away in the next 3 or 6 months. And so there'd have to be some really careful considerations before deviating from what is the most protective way to own property, and that's tenancy by the entireties.
Got it. Okay. Well, good. Well, we wrapped up title. Now we're moving on to random questions.
Oh, okay. Good. These will
Good.
hopefully come out of left field.